Another very pro-religion decision in one of the most closely watched cases of the term, Jose. This is the case of the coach, the assistant football coach out in Bremerton, Washington, who had a habit of praying on the 50-yard line immediately after games. The school district told him that he should not do that. He should find a more private place to do that because people would think that that was somehow the school endorsing his religious views or a particular religion. But today, the Supreme Court ruled 6-3 in favor of the coach in a decision written by Justice Neil Gorsuch.
The Supreme Court has once again ruled in favor of, and adding another win to the tally for, Christian nationalism in the United States.
It says, respect for religious expressions is indispensable to life in a free and diverse republic, whether those expressions take place in a sanctuary or on a field, and whether they manifest through the spoken word or a bowed head. Here's a little bit of what the dissent says. She says, today's decision is particularly misguided because it elevates the religious rights of a school official who voluntarily accepted public employment and the limits that public employment entails over those of his students who are required to attend school and who this court has long recognized are particularly vulnerable and deserving of protection. They say the court sets us on a perilous path in forcing states to entangle themselves with religion, with all our rights hanging in the balance.
So SCOTUS is busy, very busy, and they are ramping up the attacks using religion as the vehicle. Essentially, as the ACLU put it, this is a serious blow to the long-held principle that students have the religious liberty right to be free from school-sponsored prayer. Over 60 years ago, the Supreme Court recognized that it is inherently coercive for school officials to lead students in prayer while on duty. So who are the major players? What is the case, and why is this potentially a humongous problem going forward? The case was brought by a public high school football coach who claims the right to kneel and pray on the 50-yard line at the conclusion of each game, joined by those of his players who want to participate. School authorities in the town of Bremerton, Washington, told Coach Joseph Kennedy to stop his midfield praying because it violated school policy. That policy is for school employees to neither encourage nor discourage religion. The school district and the lower court said Kennedy's public praying amounted to a school endorsement of religion, and Kennedy was put on paid leave when he refused. Kennedy said he had a commitment to God to take a knee and say a brief prayer after each game right at midfield. Concerned about being sued for violating students' religious freedom rights, Bremerton, Washington public school officials asked him to stop praying publicly, but he refused. His contract was not renewed in 2015. Clarence Thomas, whose wife did her part in attempting to overturn an election and overthrow democracy while the justice did not recuse himself from Ginny's activities. Clarence Thomas, who was credibly accused of sexually harassing Anita Hill multiple times, which she testified under oath before Congress for over 4 hours. Clarence Thomas, who Hill went over in great detail of how he spoke to her graphically about sex and pornography. He asked her why she wouldn't go out with him. He commented on her clothes and even talked to Hill about the size of his privates. The same woman in Ginny Thomas, Clarence Thomas's wife, who left a voicemail to Anita Hill demanding she apologize for credibly accusing her husband of sexual harassment 20 years later. That Clarence Thomas asked how the school district would respond if, rather than taking a knee for prayer, the coach took a knee on the field during the national anthem in moral opposition to racism. As Dave Zirin rebukes, in writing my book, The Kaepernick Effect, I interviewed dozens of high school athletes who had their lives upended by coaches when they took a knee to protest racial inequity during the anthem before games. In this sick society, some knees are more equal than others. Justice Sonia Sotomayor posted a series of hypothetical questions about where to draw the line on religious speech for school employees. When, if ever, can teachers pray in class? Could the school fire a coach who decides to put a Nazi swastika on his arm and claims it is part of his religion when he goes to the middle of the field to pray, she asked. Could the school say no In her dissent, Sotomayor introduced the case as being about whether a public school must permit a school official to kneel, bow his head, and say a prayer at the center of a school event, and wrote, "The Constitution does not authorize, let alone require, public schools to embrace this conduct." Adam Best offered this perspective, played high school/college football, and grew up in the buckle of the Bible Belt. Even though I was unsure about religion, openly non-religious now, during prayer led by coaches, I felt I had no choice, even though I was uncomfortable. But standing up to the coach is a good way to get benched. Simply put, with the conservative right-wing majority, the separation of church and state is eroding before our very eyes. The decision is also the latest in a line of Supreme Court rulings for religious plaintiffs. In another recent example, the court ruled that Maine can't exclude religious schools from a program that offers tuition aid for private education, a decision that could ease religious organizations' access to taxpayer money. This is far from a complete list, but it is an indication of more such decisions to come in the future. The current court is the most pro-religion of any court in nearly 70 years, according to stats compiled for an upcoming article in the Supreme Court Review, written by law professors Lee Epstein of Washington University and Eric Posner of the University of Chicago. While the number of pro-religion outcomes edged up to 58% overall when William Rehnquist was Chief Justice, the rate has skyrocketed to over 86% in the years since then, with John Roberts as Chief Justice and the court's composition growing steadily more conservative.